Good evening to all. On behalf of CNICA, I am privileged to welcome all the participants for today's study series. The zeal and enthusiasm of the participants to the study series has been a constant source of support and inspiration for Seneca. The blueprint for the modern arbitral institution can be traced back to the medieval period to the existence of trade guilds and merchant bodies which regulated disputes within their trades by forming standing bodies dedicated to dispute resolution. A more recent ancestor of the modern arbitral institution is probably the trade association of post-industrial revolution, the most famous Liverpool Cotton Brokers Association, which was founded in 1841. Under the system set up by the Cotton Association, buyers and sellers would each nominate a broker to represent their interest, and if the two could not agree, a third broker would be selected by the association to arbitrate and break the tie. Arbitral institutions today are playing a substantial role in bringing about reform and development in the practice of arbitration. Indeed, much of the innovation that takes place in the field of arbitration procedure today comes in the form of rules, codes, and guidelines which are promulgated by the arbitral institutions. Arbitral institutions have been described as the gatekeeper to the arbitral process, playing a vital role at every stage in the life cycle of an arbitration. Arbitral institutions play a crucial role in upholding due process and shaping the rights of the parties in potentially far-reaching ways. Several dozen arbitration institutions provide dispute resolution services worldwide. Yet a rather small number of those feature in the category of truly successful and trusted institutions. It is a settled fact to ensure economic growth in this modern era of globalization of commerce. It is essential to develop and promote a strong system for public international law and a dispute resolution mechanism that resolves dispute. Even though Singapore is a tiny country, the government has taken steps to ensure that there is minimal intervention from the courts, from the country's courts in the process of arbitration. Singapore's success in international arbitration is the outcome of the strength of its legal system and the support of the government in ensuring a policy of non-intervention that has led to increase in economic efficiency. Singapore has been growing in popularity for international arbitration with the support of government policy to facilitate the best arbitration center in the region. Today, parties from all corners of the globe routinely prefer Singapore as the seat of the arbitration. The success of arbitration in Singapore and the phenomenal achievement of a Singapore International Arbitration Center, popularly called a SIAC, is due to its insatiable desire for continual improvement and its instantaneous response to the changes and requirements of the arbitration world. SIAC has always been proactive in adapting and improving its rules and procedures so as to remain in the forefront that is very competitive market. The SIAC's arbitration institution always tries to perfect the regulations from starting of a tribunal till the end. They are carefully designed to uphold the fundamental of international arbitration. The foundation principle of international arbitration, like the party autonomy, competence principle, limited procedural steps, reasonable fee structure, use of technology, and enforcement of an arbitral award can be noticed under the SIAC arbitration. Thus, SIAC manages to bring most of the commercial disputes all over the world to the country for dispute resolution. Singapore today is the Asian hub and world leader for international arbitration and has become the first choice amongst international businesses for resolution of commercial disputes. The success of SIAC is due to the handful of factors that range from elaborate arbitration rules, a broad arbitrators roster, considered pricing, marketing policy, and the functional legal system of the country of incorporation. SIAC marches ahead as a vanguard of institutional arbitration. I'm sure that all of us would be eager to hear the success story of Singapore International Arbitration Center, a most prolific and important international arbitration center, which was established just less than 3 decades ago, but could boast of centuries' growth and is in the forefront of institutional arbitration. Who else than the Chief Executive Officer of SIAC could narrate this better? We have with us today a very young, dynamic, unostentatious, forward-looking, prolific, and versatile person in Miss Seok to take us through the astonishing and gigantic success of the Singapore International Arbitration Center. May I request a chairperson to welcome the speaker. Over to you, Saravanan.
Thank you, Mr. Anand. Thank you, Mr. Ashok. Very good evening to one and all. At the first instance, CNICA extends its gratitude to K. Shanmugam, the Honorable Minister for Home Affairs and Law, Singapore, who is instrumental for today's webinar. And thanks to Jeremy Ang, Assistant Director, Industry Development, International Partnership, Ministry of Law, Singapore, who is also present here, coordinated to make this webinar materialized. International Commercial Arbitration as court. The International Chamber of Commerce was founded in 1919 to serve world business community, and the ICC's International Court of Arbitration was created in 1923. The need of establishing institutional arbitration in Asian and African continents were addressed by the Asian African Legal Consultative Organization, shortly called as ALCO, which launched its integrated scheme for settlement of disputes in economic and commercial transactions in the year 1978. Pursuant to that scheme, ALCO decided to establish regional arbitration centers under its auspices, which would function as international institutions with the objectives of promoting international commercial arbitration in the Asian African regions and providing for the conduct of international arbitrations under the auspices of such centers. This was the time when the Kuala Lumpur Regional Center for Arbitration and the Cairo Regional Center for International Commercial Arbitration were established in the year 1978 and 1979 respectively. The creation of arbitration centers in Asia and Africa made institutional arbitration accessible to Asian and African users. As far as India is concerned, even much prior to the establishment of Kuala Lumpur and Cairo arbitration centers, the Indian Council of Arbitration was set up pursuant to recommendation of the Indian Ministry of Commerce in the year 1965 as a specialized arbitral body at the national level during the subsistence of the Arbitration Act 1940. In 1995, in India, the Arbitration Conciliation Ordinance was promulgated. The said ordinance was based on the UNCITRAL model law, which recognized institutional arbitration. Hence, the International Center for Alternative Dispute Resolution, shortly called as ICADR, was established in the year 1995, hoping that it will act as a launchpad for institutional arbitration in India. In those lines, the idea of establishing the Council for National and International Commercial Arbitration, shortly called as CNICA, was conceived in the year 2001 and was registered in the year 2004 as a trust under the aegis of Trust for Dispute Resolution. As far as Singapore is concerned, the Singapore International Arbitration Center, shortly called as SIAC, was set up in March 1990 as a non-profit public company limited by the Economic Development Board and the then Trade Development Board to speed up the settlement of commercial disputes since 1991, with the main objective of developing Singapore to be a regional and international hub for commercial arbitration. Singapore has emerged as one of the world's leading centers for international commercial arbitration, and that the reasons are open secret. In the first place, Singapore is blessed with an excellent geographic location situated in the heart of Southeast Asia, surrounded by Indonesia, Malaysia, and Thailand, and location of the giant countries like China to the east and India to the west. Singapore is a modern, clean, and extremely efficient country with an excellent infrastructure and world-class communications. Its government and courts have a reputation for integrity and competence. The courts of Singapore are extremely supportive to the object of international commercial arbitrations in terms of striving to uphold arbitration agreements, enforcing interim measures and foreign awards, and its clear view on the doctrine of public policy. In short, Singapore is seen as a neutral venue, I would say as a natural venue for holding the international commercial arbitration. No doubt, in view of the success of the Singapore International Arbitration Center, the abbreviation SIAC has become a trendsetter in the institutional arbitration community of the universe, which is evident from renaming of KLRCA as Asian International Arbitration Center, shortly called as IAC, and forming of Dubai International Arbitration Center, shortly called as DIAC. And there are many other acts in the line of SIAC, IAC, and DIAC. There has always been an active relationship between SIAC and India, where Indian clients played a very prominent role in SIAC. This growing trend follows from the recent years, where the number of new cases involving at least one Indian party has grown steadily, increasing tenfold in the period from 2001 to 2012. Recognizing the significant role played by India towards SIAC's success as an international arbitration institution, SIAC established a presence in India to interact closely with the business and legal communities in India and develop greater awareness of institutional arbitration. This has made SIAC to open its representative office in Mumbai in 2013 and its second representative office in Gujarat in 2017. Indian parties are the top arbitration users in SIAC arbitrations. In these circumstances, Seneca has thought it fit to hear the experiences of SIAC in reaching its great height, as it would be beneficial for the other arbitration centers and arbitration practitioners of various countries, including the governments of the respective countries. The story of success teller is Ms. Lim Seok Hui, the Chief Executive Officer of SIAC. Ms. Seok Hui formerly practiced in Singapore and Hong Kong SAR as a corporate and merger acquisition lawyer with international as well as Singapore law firms, and has also held general counsel positions in various multinational corporations. She was called to the Singapore bar and the bar of England and Wales, and was also admitted as a solicitor in England and Wales and Hong Kong SAR. Ms. Seok Hui previously held a concurrent role as the first Chief Executive Officer of the Singapore International Mediation Center and currently sits on the board of directors of SIMC. As the Chief Executive Officer, Ms. Seok Hui is responsible for the overall management and operations of SIAC, including business development. With this note, on behalf of CNICA, I welcome and request Ms. Lim Seok Hui to tell the story. Thank you. Over to you, madam.
Thank you very much. I'd like to say good evening. Thank you, Mr. Anand and Mr. Saravanan, for your very kind words and the excellent introduction. I almost feel that you have covered everything I was intending to say, but far better than I could have. So, and good evening to all our attendees today. Thank you so much, Seneca, for inviting me to be a speaker. The topic today is the success story of the SIAC. And as I was telling Mr. Saravanan the other day, I was a little bit embarrassed by the title, because success never stands still. We can't afford to take it for granted. And I'd like to think we are still on a journey. And it's an exciting one. And I can share with you today the factors that has led us to where we are. We've achieved a small measure of success, but there is a great deal more to do. So with that, if we could move on to the first slide. I will divide my presentation into three main parts. In the first one, I'll talk a little bit about the international arbitration ecosystem, the framework in Singapore. Then I'll go on to introduce the people at SIAC. And then finally, I'll touch on the rules at SIAC. So to start with, Singapore and SIAC, the reason for its popularity boils down to three things: neutrality, a trusted legal system, and stability. If you look on the current slide, Singapore is currently amongst the top 3 most popular seats of arbitration in the world. and SIAC is amongst the world's top 3 arbitral institutions. In terms of the international administered caseload, however, SIAC is currently number 2 in the world, behind the ICC. We overtook the LCIA, the London Courts of International Arbitration, in 2016, and we've constantly exceeded LCIA's caseload in each of the last 4 years. Singapore, as you know, as our Indian users know, is a trade and services hub and a leading dispute resolution hub. We are conveniently located in Southeast Asia, close to our Indian users, Chinese users, and a lot of our key Asian users. We have excellent flight connectivity. This is pre-COVID, but we are connected by flights to anywhere and everywhere. And so parties choose to come here to Singapore to arbitrate. They choose Singapore as a venue. But of course, it's entirely up to Indian parties to have their arbitrations, their hearings held in India. A little bit of history here in terms of what Singapore did to make the framework more arbitration friendly. In 1994, we amended the International Arbitration Act to incorporate the UNCITRAL model law, the UNCITRAL model law of 1985. This was a key change. The UNCITRAL model law brings together common law and civil law systems, whereas prior to that, Singapore's arbitration legislation had been guided by English law. The International Arbitration Act, or the IAA, gives effect to Singapore's obligations as a signatory of the New York Convention. The judiciary in Singapore has always been known to be supportive of arbitration, and by that we mean minimal intervention in arbitral proceedings. We have a specialist bench of judges who hear arbitration matters. In terms of user friendliness, there is no restriction whatsoever on foreign counsel conducting arbitrations in Singapore. You can bring your Indian lawyers with you into Singapore. You don't need separate Singapore counsel, although you can co-counsel with Singapore law firms in your arbitrations here. There are no restrictions, no registration requirements, no special visa requirements that you need to come into Singapore, come in and out to do your arbitrations. Enforceability, again, our awards have been enforced in a number of countries all over the world, including India. And under the New York Convention, which currently has over 160 member states, that is not an issue. In terms of world-class infrastructure, so back in 2010, Maxwell Chambers, who many of you who have visited Singapore for arbitrations would be familiar with, it's a former colonial government building that is now the world's first integrated ADR complex. It houses, you can see from this slide, in the top middle, that would be the colonial building, that structure I was referring to. But inside, it's completely renovated, completely modern. So on the current slide, you will see different sizes of hearing rooms, as well as breakout rooms. And within Maxwell, so last year, Maxwell Chambers tripled its capacity. So the building you see in the current slide is all hearing rooms only, and that includes rooms for mediation as well. And if we move on to the next slide, I'll show you, and this slide, Maxwell Chambers Suites, which is right next door to that colonial building, Maxwell Chambers, and connected by an overhead bridge you see on the top right corner, in the top right corner. Maxwell Chambers Suites is completely new, and it houses SIAC and other dispute resolution institutions such as the SIMC, that's the Singapore International Mediation Center, as well as the Permanent Court of Arbitration, the PCA, as well as WIPO. And it houses also arbitration chambers, barristers' chambers, and law firms. So it's an integrated dispute resolution complex. Maxwell Chambers, in terms of hearing facilities, offers state-of-the-art video conferencing facilities. They can arrange and they provide transcription services, translation services, catering services, of course, and 24/7 administrative support. And now, during this uncertain period of the COVID pandemic, they also provide virtual hearing solutions for parties. Moving on, and if we could go back to the slide on framework, Shweta. Thank you. In terms of user-friendly, arbitration-friendly legislation, third-party funding is permitted for international arbitration and related proceedings. The SICC, that's the Singapore International Commercial Court, that was established in early 2015, is empowered to hear applications under the International Arbitration Act. So it has the same jurisdiction as the High Court in Singapore to hear proceedings related to international arbitration, such as applications to set aside awards and enforcement applications. The most recent arbitration-friendly legislation introduced was an amendment to the IAA to clarify that disputes in relation to intellectual property rights are arbitrable, and an arbitral award concerning intellectual property rights shall not be considered contrary to public policy. So moving along now, Shweta, if you could skip the photographs, and I'd like to talk about a quick overview of SIAC. In terms of history, as Mr. Saravanan mentioned, we started operations in July of 1991. So next year, we celebrate our 30th anniversary. Fairly young institution, very energetic, and we're excited always to innovate. That I think is what we're all about and what we always strive to do. We are an independent, not-for-profit organization. In terms of caseload, and our next slide, if we could move on to that very quickly, shows you since inception, since 1991, where we started with a grand total of 2 cases. Over the years, and particularly over the last decade, since 2009 or so, our caseload has tripled since 2009, and we are now currently at, as of last year, 2019, in terms of new cases filed, 479 cases. Shweta, if we could move back 1 slide. The active caseload that we actually have is over 800 cases managed by our SIAC Secretariat, our counsel, our lawyers in the team, which I will talk about a little bit later. Over 80% of our cases these days are international in nature. At least one party is foreign, or the subject matter has no connection with Singapore. Of that, over half of our cases have no connection with Singapore whatsoever. And this is a change from when we started almost 30 years ago, when we started largely as a domestic institution. And then we evolved into a regional institution. And today we are a global institution, as I said, amongst the top 3 in the world. Our caseload is global. Parties come from all over the world. On average, we see parties from about 60 jurisdictions each year. In the last 5 years, we've had parties from over 100 jurisdictions, from common and civil law systems. In terms of the sum and dispute, in the last 5 years, the aggregate sum and dispute has exceeded 35 billion US dollars. So these days, we are seeing increasingly complex, high-value cases. Our rules, we try to keep on enhancing and improving our rules to ensure that for you, our users, we try and save time and costs for our users. In fact, we just announced just last week that we are into our next rules revision exercise. Our new edition, the 7th edition of the SIAC rules, will be launched sometime next year in 2021 to coincide with our 30th anniversary. Moving along, Shweta. So the next slide, and I've talked about, okay, so total new cases received last year, 2019, 479, of which about 95% or 454 cases were administered by SIAC, were managed by our Secretariat. And the remainder, the 25 cases, were where we appointed arbitrators in ad hoc cases. Moving along. So in terms of the top 10 foreign users in 2019, again, as Mr. Saravanan and Mr. Anand had mentioned, India is and has always been a top foreign user of SIAC. As you can see, it was far and away our top foreign user last year. That trend continues. And again, a recent trend, and by recent I mean in the last 5 years or so, is our mix of foreign users in the top 10. So in addition to India, China, and other Asian jurisdictions such as Malaysia, Indonesia, Thailand, the Philippines that you see on the current slide, we've always had US parties within our top 5, our top 3 foreign users. And in the last few years, we've had the Middle East, the UAE, as well as European parties from Germany and Switzerland last year. So that is a good mix of civil and common law jurisdictions. Moving along to the next slide, in terms of dispute sectors, this roughly is roughly year on year, you would see a good mix of corporate. Last year was at 29%, followed by trade disputes at 21%, commercial at 16%, construction, again, a popular sector, others, which would include financial services, IP disputes, insurance, and then you have maritime and shipping cases. So moving along to SIAC's people. On this, in terms of history and the starting of SIAC story, in a sense, Minister Shanmugam in 2008 decided to internationalize SIAC by internationalizing its board. And he invited Dr. Michael Pryles to be chairman of the board. And so Dr. Pryles joined us in 2009. And the board then included superstars, arbitration superstars from the UK, Europe, as well as Asia. And then in April of 2013, SIAC adopted a new management structure with a board and separately a court of arbitration with different functions and focus. So Mr. Lucien Wong, who is now the Attorney General of Singapore, took over as chairman of SIAC in 2013. Dr. Pryles became the first founding president of the SIAC Court of Arbitration. And together, they then worked together, and under their visionary leadership, our cases grew, we expanded. And then in 2016, Mr. Davinder Singh took over as chairman when Mr. Lucien Wong became the Attorney General. And Mr. Singh is widely feted as Asia Pacific's leading litigation counsel. And also in 2015, Mr. Gary Bourne took over the baton from Dr. Pryles as president of the SIAC Court of Arbitration. And Mr. Gary Bourne truly needs no introduction. He is one of the superstars in arbitration. So we are very, very fortunate indeed to have as our chairman and as our presidents, both past and present, truly visionary, inspirational leaders. And that has made a big difference. So the board looks after corporate governance, business development, and the operations of SIAC. And the Court of Arbitration, composed of 32 top arbitration experts from around the world, supervise case administration. The court decides applications for consolidation, joinder, challenges to arbitrators, and jurisdictional objections. We have, and if Shweta could move on firstly to the photographs of our board of directors, where we have Mr. Rajiv Luthra as our Indian board member, familiar face to all of you, I'm sure, as well as many other top names in the corporate world, in the arbitration world, as our board members. And moving along to the next slide, you will see our Court of Arbitration led by Mr. Gary Bourne as president, two vice presidents, Mr. Kavinder Bull and Professor Lucy Reed. And you will see that we have 4 Indian court members, Mr. Harish Salve, Mr. Darius Kambata, Mr. Tejas Karia, and Ms. Shaneen Parikh. And in addition to that, as I mentioned, arbitration practitioners and leading arbitrators from all over the world, from the US, the UK, Europe, Australia, Belgium, etc. And then the next slide, our secretariat. We have 2 Indian counsel on our secretariat. In addition, we have, reflecting the multinational nature of the Court of Arbitration, we have, as counsel in the secretariat, we have counsel from China, from Malaysia, from the Philippines, Indonesia, Spain, Lithuania, as well as Singapore, and Canada, of course. Together, they work with the SIAC Court of Arbitration closely in case management. So the key functions, as you will see on the current slide, of the Secretariat would include the appointment of arbitrators under our rules when parties are unable to agree, as well as in ad hoc arbitrations. The Secretariat supervise and monitor the progress of a case. We collect deposits, and then we pay out arbitrators' fees and our own SIAC's arbitration fees. The tribunal's fees are fixed under our rules according to a schedule based on, the default will be based on the ad valorem, the total amount, the total sum in dispute, which would be the total amount of all claims and counterclaims. And at the end of an arbitration, our registrar would determine the costs of arbitration, the arbitrator's fees, as well as the institution's fees. An important part of what we do is the scrutiny of draft awards. So if we could move to the next slide, what is scrutiny? On the left side of this slide, these sets out a few points that we look for when we scrutinize a draft award submitted to us by the tribunal. We try and look for the procedural history. Has this been clearly set out by the tribunal? Have there been any procedural irregularities that need to be addressed? Has the tribunal set out the issues completely and accurately? Does the award deal with all of the issues in dispute, or has the tribunal overreached and exceeded their scope? have all parties been given an opportunity to be heard, to address all of the issues in dispute? What this does, and it's not performed by all arbitral institutions, what this does is to improve and enhance the enforceability of the award. So it is a value add, it is labor intensive. That's why we have a team of currently 12 counsel, together with the registrar and the deputy registrar. That would be 14 in total on the Secretariat. So moving along to the next slide. The SIAC panel of arbitrators, which includes, and the way we divide it, it's all up on our website with the CVs of the arbitrators. We have many from India, as you would imagine. We have in total over 500 expert arbitrators from over 40 jurisdictions. In terms of key areas such as energy and EPC, we have over 100 arbitrators on our panel. Separately, we have a specialist IP panel of arbitrators as well. Parties are free to nominate arbitrators off panel who are not on the SIAC panel. SIAC itself is free to nominate, to appoint arbitrators who are not on our panel, and also to appoint arbitrators who are on our panel. So to join the panel, we have high admission standards. You can see on the current slide, minimum of 10 years post-qualification experience, fellowship of either the Chartered Institute of Arbitrators or the Singapore Institute of Arbitrators. You must have acted as an arbitrator in at least 5 cases, and you must have written at least 2 awards, either as a presiding arbitrator or as a sole arbitrator. And the Code of Ethics requires every arbitrator to confirm to us and give a written undertaking that you will discharge your duties without bias. You'll be impartial, you'll be efficient, and you'll devote sufficient time and be committed to resolving the case in as expeditious, fair, and efficient manner as possible. Moving on to the next slide, geographical diversity in arbitrator appointments. As you can see, we appoint arbitrators not only from Singapore and those based in Singapore of different nationalities, but really arbitrators from all over the world. And that reflects the diversity of the parties in cases that we see, parties from diverse legal systems and diverse cultures. Moving along, in terms of gender diversity, we try hard to do our part as an institution to appoint female arbitrators. As you can see, we are amongst the top few institutions in the world now. Last year, 36.5% of the 159 arbitrators appointed by SIAC were women, and that was an increase from the previous year. Now, moving along to our rules, the time and cost savings mechanisms under our rules. This current slide is a snapshot of the various time and cost saving measures you will find under our rules, and I will take you through each in turn. The emergency arbitration procedure, a very popular one, was introduced, and we were the first Asian arbitral institution to introduce that back in 2010, so a decade ago. It's been extremely popular. We are a world leader in emergency arbitrations. That one, we enhanced our rules in the 2016 rules to provide, Shweta, if we could go back to the previous slide. The 2 key changes then, it were to quicken the process for appointment of an EA, an emergency arbitrator. to make it within 1 day, and that is 1 calendar day instead of 1 business day. So typically, and today is a Friday, this is when, and this hour is usually about the time we receive an emergency arbitrator application from parties, usually concurrently with a notice of application. So what this means, that change, is that, you know, through the weekend we work, and you will get your emergency arbitrator appointment by tomorrow, by Saturday. And so that is a key change to expedite that process of appointment. And the other key change in the 2016 rules, key change from the 2013 ones, was to require the issuance of the emergency arbitrator order or award of interim relief to be made within 14 days, which is a very tight timeline from the appointment of the emergency arbitrator. So if we could go to the next slide. Very quickly, I had mentioned the appointment within 1 day. Any challenge to the EA must be made within 2 days of the arbitrator EA appointment. And the application then is accepted or rejected. In all cases so far to date, we've accepted the applications, and that decision is made by the president, Mr. Gary Bourne, of the Court of Arbitration. And typically, the schedule for consideration of that application is made within 2 days of appointment of the emergency arbitrator. And the emergency arbitrator has the same powers as the tribunal to order any form of interim relief. And what does any form of interim relief mean? The next slide will show you some typical examples. Very often, you will see a request for a freezing order against the dissipation of assets, or you will see an order restraining the respondent from calling on a performance bond or a bank guarantee. So if we could move on to the next slide. In practice, we see a very high rate of voluntary compliance of EA orders or awards. Another example of the Singapore legislation being user-friendly and pro-arbitration is that back in 2012, the International Arbitration Act was amended to make EA orders and awards enforceable in Singapore-seated arbitrations, as well as foreign-seated arbitrations outside of Singapore. Hong Kong has also adopted similar legislation. But as I said, even though other jurisdictions, other countries may not have done so, we do see in practice a high rate of voluntary compliance. And this is probably due to the respondent not wanting to create an adverse or unfavorable impression on the tribunal, which hasn't been appointed yet. You know, typically the emergency arbitrator is appointed for urgent cases before the tribunal is constituted. So the respondent wouldn't want typically to create an adverse impression on the tribunal, which is why you see a high rate of voluntary compliance. Now, the next slide will show you very quickly, and I won't really go into it, what the timeline is typically for an emergency arbitration that is completed. As I said, it has to be completed within 14 days under our rules. And moving on, you will see that parties involved in EA cases come from all over the world. And the sectors where we see EA cases again are a very good spread. On the next slide, Shweta. Thank you. And then finally, the next slide will show you the outcomes of the 107 emergency arbitrator cases that we've seen to date. So you will see that about 35 have been granted, and 7 have been granted by consent, some partially. So about half and half, if you wanted to see of those rejected and accepted. In terms of the fees, you will see at the bottom of the current slide that the total would be 35,000 Singapore dollars. Moving on to expedited procedure. Again, a very, very popular procedure under our rules to date. And this was introduced at the same time as the emergency arbitration procedure back in 2010, a decade ago. And since then, we've had a total of over 570 expedited procedure applications, of which, over half, more than half, have been granted to date. This is a fast track 6-month. If you could go back again, yeah, fast track 6-month arbitration procedure, which is tailored and very suitable for the less complex, more straightforward, lower value claims. And by lower value, the threshold set in the rules is 6 million Singapore dollars, which is around 4.5 million US dollars or so. So there are 3 limbs. One is this dollar threshold, or if both parties agree, both sides agree to the expedited procedure, or in cases of exceptional urgency. Or you can combine any of these 3 limbs in your application. Again, the precedent of the court, Gary Bourne, decides on whether an expedited procedure goes ahead. If it does, the matter is referred to one arbitrator. So there you save your time and cost. Instead of 3 arbitrators, you have 1. And you save time, your own legal fees, because it is a compressed timeline of 6 months. And the award has to be made, as I said, within 6 months. So you save fees all round and you get your result very quickly. So moving along to the early dismissal procedure. Shweta. So this was a new one, a new procedure that was introduced, and we were the very first commercial arbitral institution in the world to introduce this in our 2016 rules. It was groundbreaking. It was modeled on the ICSID Rule 41.5, but we went further. So in addition to the limb you see on the current slide, manifestly without legal merit, we added another limb, which is manifestly outside tribunal's jurisdiction. So what this procedure does and what parties can do is to apply to the tribunal for the dismissal of a claim or a defense. And that is where we also went further than the ICSID rule on which this was based, where you can also apply to strike out a defense. And so this is very flexible. It can be used together with any one of our time and cost savings measures. For instance, the expedited procedure. You can try and use the early dismissal to strike out unmeritorious claims or defenses, and then have your dispute resolved in 6 months under the expedited procedure. So it is very useful to be able to combine any number of our time and cost savings measures. As a safeguard against abuse of this procedure, the tribunal has the discretion to act as gatekeeper to decide whether an application should be allowed to proceed. And if the tribunal so decides, then it has to issue an order whether or not the application is granted within 60 days of the date of the application for early dismissal. This has been very popular since it was introduced in 2016, in August of 2016. We've had, as you can see on the current slide, 32 applications to date, of which 19 were allowed to proceed, and at the bottom you can see the final outcome. And if we could move along to another time and cost savings mechanisms, or 2 rather, the consolidation and separately the joint applications. So if you have related agreements and related disputes, any party can make an application for consolidation of multiple arbitrations. That application can be made to the SIAC court if that is prior to constitution of tribunal, or if the tribunal has been constituted, then directly to the tribunal. Again, you save time and costs because of, instead of paying for multiple sets of arbitrators of tribunals, you pay for only one set under the consolidated arbitration. You also ensure consistency in the decisions so that you don't have conflicting decisions made by different sets of tribunal. Joinder allows parties and non-parties to arbitrations to be joined. Again, that's another useful time and cost savings measure. And moving on to multiple contracts, under our rules, and that's Rule 6.1a or 6.1b, parties have the flexibility if you have, to either file multiple notices of arbitration with a single filing fee and then submit an application for consolidation, or you can, if you wish, file a single, just one notice of arbitration for multiple arbitration agreements. In both cases, you file a single filing fee, and depending on the outcome, if for those cases which may not, where you don't get your consolidation application granted, you then pay up the balance of your filing fees if application for consolidation is not granted for one or more cases. So again, very useful to have a very robust procedure. And our consolidation procedure is very robust, as I said, because you don't need complete identity of parties, unlike those of other institutional rules. If you have, for instance, in one contract, parties A and party B, and in another contract, party B and party C, you can apply to consolidate both arbitrations, even though you don't have exact identity of the parties. So you don't need party A and B throughout in order to apply for consolidation. And finally, another useful time and cost savings mechanism is that you can apply to the tribunal for an order for reimbursement of unpaid deposits towards the cost of the arbitration. So when you have, for instance, a respondent who hasn't paid up its share of the deposits, and the claimant then pays both its share of the deposit as well as the respondent's share of the deposit in order to move along the arbitration, the claimant can then apply to the tribunal for an order to require the respondent to pay up its share of unpaid deposits. And then finally, the ARB-MED-ARB protocol. And on this one, we teamed up with the SIMC back in 2014. So SIMC is the Singapore International Mediation Center, which was set up in November of 2014 for mediation of international commercial disputes. So SIAC teamed up with SIMC as its sister organization to offer parties a seamless one-stop ARB-MED-ARB protocol. And what this is it's a hybrid ADR process where you file your notice of arbitration at the SIAC, pleadings are then exchanged by parties, you appoint your arbitrator, and then you suspend the arbitration proceedings. You then move on to mediation, where the default is to appoint somebody else, not the arbitrator, as the mediator, and the SIMC has an expert panel of mediators, the world's best, on its about 70 of them on its panel, on its website, with their profiles on the website. You appoint that person as the mediator, or if parties wish, it's completely flexible. You can appoint the arbitrator as the mediator, to be the mediator, and to then try mediation for a period of 8 weeks, which again is a flexible timeline because it can be shortened or extended by agreement of the parties. So if the mediation is successful, parties have the option of requesting that the mediated settlement agreement be made a consent arbitral award, which gives the advantages of enforceability under the New York Convention. And if the mediation is unsuccessful, parties can go seamlessly back to arbitration because, as I mentioned earlier, they would already have appointed an arbitrator. And here I would like to mention the signing last year of the Singapore Convention on Mediation, which is a very significant milestone for mediation. The Singapore Convention, as it's widely known, it will be ratified shortly in September of this year, and India is a signatory to that convention, and it will do for mediation what the New York Convention has done for arbitration, which is to ensure that mediated settlement agreements are enforced in member states to the Singapore Convention. So that is definitely a very positive trend. But in the meantime, ARBMEDAP is a very useful process for parties, where even if you can't mediate and settle the dispute entirely, you can at least streamline the issues in dispute by mediating and settling some of the disputes and then arbitrating the outstanding issues. Now, the settlement rate for mediations at the SIMC is very high, as you can see on the current slide, over 80%. And you will see also that Indian parties have been very supportive of mediation. There have been 21 ARBMEDAP cases to date. In total, 95 mediation cases, of which 21 were ARBMEDAP cases. In both the mediation as well as the ARBMEDAP cases, you can see that many parties, including Indian parties. So, if we could move on. Sorry, that was there were 116, as I see now on the previous slide, mediation cases to date, and of which 95 were mediation cases and 21 were ARBMEDAP cases. So, the next slide will show you where worldwide, on the final one, the investment arbitration rules. On the 1st of January 2017, SIAC introduced a separate set of investment arbitration rules. And this is a specialized set of rules to address unique issues in investment arbitration. It is not only for investor-state arbitration, parties in commercial disputes can also opt in to the investment arbitration rules if they wish. And a point to note is SIAC was included in the Singapore-Sri Lanka Free Trade Agreement as an arbitral institution option. So hopefully we will see parties start to use the investment arbitration rules. And the next slide is where we have overseas representative offices. So case management functions are performed only in Singapore, but overseas and in India, we have two representative liaison offices, which perform promotional and marketing activities. And in 2013, we set up the Mumbai office, and a couple of years later, we set up the Gift City office in Gujarat. Elsewhere in China, in Shanghai, we have a representative office. In South Korea, in Seoul, our office there looks after Northeast Asia, including Japan and Korea. And so that is where we have representatives to engage closely with local stakeholders. And to promote and join. I'd like to wrap up very quickly to talk a little bit about what else, our engagement with users all over the world and with our Indian users. So we have a users council, a global one, and it's made up of a large number of Indian practitioners, Indian arbitrators in DC. We also set up a few years ago the Young SIAC, and Young is under 40. And this is a very dynamic group of younger practitioners all over the world. We have a committee that is very energetic. They organize a lot of training events and training workshops, advocacy workshops. And on that committee, we have 4 committee members from India. In terms of thought leadership, we've been focusing on that. We are committed to that. We have the SIAC Academy, which is a training program for both counsel as well as arbitrators. And we started that in Singapore, and we have exported it overseas, including to India and many other jurisdictions in Asia. We also have the SIAC and Institutional Arbitration module, which we launched at National University of Singapore, the NUS, and we have exported that and are exporting it to many universities, including in India, China, elsewhere. In India, we work closely with many universities, including NLS in Bangalore, NALSA in Hyderabad, NLIU in Bhopal, just to name a few. We also do many guest lectures with these universities. And again, to summarize what we at SIAC try to do, I would say, I used to say it was the 5 E's of arbitration, and now actually it is 6 E's. And I will very quickly go through them. The first E is efficiency. We strive to deliver world-class services at all times. The next E, the second E, is expedition. And I've taken you through our various time and cost savings measures. The third E is even-handedness. And even-handedness, I would say, neutrality as an institution, and also the light touch, where we manage a case, but we give full effect to party autonomy. The fourth E, expertise. Expertise in terms of the court of arbitration, our secretariat, our panel of arbitrators. The fifth E, enforceability of our awards all over the world. And finally, and that is very relevant in current times, in COVID times, the sixth E is going electronic and having virtual hearings. And our rules, in our rules revision process, we will be looking to make our rules even more friendly and to accommodate virtual hearings and online solutions. So finally, I'd like to say, as I started and I said, this is a journey, and my request is to hear from you, our users. Let us know what we do well. Let us know what we can do better, and let us know what more we can do. Thank you.
That was an excellent presentation. What else one can expect from the CEO? We have a few questions and, on the chat box. This one is from Saravanan himself. In India, especially New Delhi International Arbitration Center is going to set up. Do you foresee that it will be a competitor to SIAC?
I don't see it as competition. I see it as a collaboration. We always welcome another institution to join us, because together, the axis of arbitration has shifted in the 21st century to Asia. And there are many, it's not just SIAC, but there are many, many more institutions, and you yourself named them earlier. There's the SIAC, of course, there's the ICC, there's the HKIAC, there's the AIAC, and many others. And, together, we will jointly what we will do is to jointly extend our outreach to users everywhere to jointly promote international arbitration as the preferred form of dispute resolution for cross-border commercial disputes.
Okay. Anand has got a question. He'll be asking you now.
Ms. Seok, I should
Yes.
say that it was a very interesting presentation, a presentation that was remarkable for its clarity and lucidity.
Thank you.
SIAC has been proactive in adapting and improving its rules and procedures and responsive to changes. I think one such thing was Rule 28 and 29 of SIAC Rules 2016 relating to summary judgment and emergency arbitration. Very few countries have recognized emergency arbitration. Has it been an impediment for SIAC? How effective these provisions have been in the arbitration process? And what is the response of the arbitral community to these two provisions?
All very good questions. Thank you. As I mentioned earlier, even though Singapore and Hong Kong were the first and the only so far to introduce emergency arbitration legislation, in the sense that emergency arbitrator orders and awards can be enforced in these jurisdictions, what we have seen is a high rate of voluntary compliance. And in fact, the Indian courts have been very supportive of this. We've had a few cases where the parties took the emergency arbitrator award from SIAC and went to apply to the Indian courts for similar court orders for interim relief, and these were granted. So effectively, that would be enforcing the emergency arbitrator awards. So it has been a very positive and very effective tool. And as you can see, when I showed the slide on the number of applications we've had to date, 107, that is a world leader. And that goes to the popularity of this procedure as a very useful tool for obtaining urgent interim relief prior to constitution of the tribunal.
Okay. Saravanan has got one more question. This is a suggestive one. What measures do you suggest to develop an arbitration center in a country like India?
It is everything that I said earlier about, I shared with you what the factors that have led to the SIAC, the success story in a sense, and our journey, and that was the strong international arbitration ecosystem within Singapore. And on that, I touched on the judiciary, the government support in terms of the legislation, factors such as the parties enabling parties to bring the foreign counsel in easily to appear in arbitrations in Singapore, and in terms of the infrastructure at Maxwell Chambers, the hearing facilities, development of the local bar, both in terms of the local Singapore firms as well as the international firms, encouraging them all to come to Singapore to establish practices in Singapore in the case of the international firms. So all that, and then that's the framework I spoke about. And then the second thing I spoke about was the people. And then the third thing was the rules. And our rules are amongst the most progressive and user-friendly in the world. And we mustn't rest on our laurels, as I said at the beginning of my presentation. And that is why we have embarked on our next rules revision process to see what more we can do to make them even more efficient, even more innovative, and even more friendly for our users.
I'm sure this Thrive is only making SIAC to the top of the world now in arbitration. They try to find out what more can be done. With that, I have, as a treasurer of CNICA, I have one question. When did SIAC attain its break-even, and how fast could you achieve that?
We are self-sustaining. And I won't say anything more. But
I understand. Okay. I don't find any, one second, I'll just check out with the, there are a lot of appreciations for your presentation in the chat box. And with that, I don't think so there is any further queries. So now I call upon our member Mahadevi to adduce vote of thanks. Mahadevi, you may unmute yourself and yes.
Very inspiring and motivating session to all the participants, and especially to the arbitration youth like Sinika. Talk about what you accomplish in your life. We, the galvanized participants of today's session, become fortunate to encounter the successful story of Singapore International Arbitration Center. The SIAC envisions to be the number one where the world arbitrates. The core values of the SIAC are one global network, unique opportunities, relentless pursuit in excellence, social responsibility, integrity, accountability, and collegiality. I mention my deep appreciation to Ms. Seok Hui, the Chief Executive Officer of the SIAC, the most suitable person to share the success of an esteemed institution. It was very delightful, ma'am. I thank Sinika for organizing a knowledge-provoking webinar among the pandemic. And I thank my incredible participants without whom this session wouldn't be much successful. Once again, I thank Sinika for giving me the opportunity to render vote of thanks for today's session. Thank you.
We do recognize the presence of Justice Radhakrishnan, former tribunal consumer member Dr. Gupta, and also our friend from earlier who was in SIAC, Ganesh Chandru. And with that, I now take your permission to end the session. Thank you.
Thank you, Ms. Seok. Thank you, Shweta.